Saturday morning, we kick off the Experts program, and that means it's time to talk technology with Louis Alvarez, CEO of the Alvarez Technology Group. Good morning, Louis.
Good morning, Mark. How are you?
Doing pretty good. So we have a really interesting topic to start the program off with today, and it has to do with something that is less than a couple of months away, less than 60 days away. We're going to get hit, everybody in California, with the California Consumer Privacy Act. It's an online privacy act concerning how your data is handled by all types of businesses, and it goes into effect on January 1st of 2020. And you were telling me off the air that from what you've seen, most people, particularly businesses, are unprepared for this. And first and foremost, what is this Consumer Privacy Act?
So, most people are not ready. Most people don't even know what it is. So that's a good place to start. The California Consumer Privacy Act, or CCPA, as it's become known, is something that was approved last year. It took a while to finalize the details, which just basically got done within the last 30 or 40 days. And so what it is a new law that protects consumers' privacy, much like the European GDPR rules that are trying to ensure that people have the ability to know, for example, who's collecting their information, what that information is being used for. They should be able to opt out of having their information collected. They should be able to request all the information that's been collected on them to be produced. And for, somebody like a Google or a Facebook that's already been geared up for the GDPR, this is just another thing, another cost of doing business. And from a consumer perspective, there's some good things in there. Consumers generally don't do a good job of protecting themselves until after the fact. So having the state mandate some base protections isn't bad in and of itself. The problem is that everything California touches, or at least the California legislature, they tend to go a little bit overboard.
Right.
And so there's a lot of language in the CCPA that could be very damaging to businesses in much the same way as originally the ADA.
Americans with Disability Act.
Yeah, when that first came out, there was a lot of nebulous language in there, and it gave lawyers the opportunity to go after a bunch of people that really, it was not the intent of the law. And unfortunately, the way that the CCPA is written, businesses have to become much more knowledgeable, much more proactive, because otherwise, just like the ADA compliance laws caused a lot of civil lawsuits, the same thing might happen with the CPA.
So how is this going to work? Exactly what does it require of businesses? And who's covered by this?
So that's a good start. The businesses that have to comply with the CCPA are those that generate $25 million or more in annual revenue. So, for a lot of businesses, they kind of wipe their brow and say, great, I'm not included. But there's other provisions. Another one is that they generate 50% or more of their annual revenue from selling information that they gather from consumers. Or the last one, and this is where a lot of businesses are going to get caught up, because it says that you have 50,000 or more records of California residents, households, or devices. So 50,000 sounds like a big number, but if you've been in business for a few years, the chances are that your database, even the systems that you use to manage your business have collected at least that much information or that many records. And so you might be required to comply with the law. And compliance is not trivial. For example, your website has to clearly state what the conditions are that people's information is being gathered, and gives people the ability to request all that information, and as well as opt out if they don't want their information being gathered. You have to have a lot of what we consider cybersecurity in place to protect that data, so that if there's some sort of breach, that the people that are affected by that breach are notified. And if you don't follow all the regulations to the T, then you open yourself up to some pretty stiff fines, which get into the millions of dollars, depending on the number of records that you have and that were compromised.
Let me clarify something with you. One of the first things you said is that if your business does 25 million or more in sales, you have to comply with this. Then you added the thing about 50,000 records. So does that mean any business with 50,000 records? So let's say I've got an ice cream store and I have an online presence, and maybe I gross $250,000 a year, but I've been in business for a long time and I've got 50,000 customer records from my website, or people signing up for contests, to get a free ice cream cone on their birthday, that kind of thing. Am I going to be snared by this?
You are.
Wow.
So you have a couple of options, and this is what we're talking to our clients about right now, which is, one, if you just accumulated a bunch of records and you don't need them, purge those records. record.
I was going to say, the cheap and easy way to deal with this is a 5-letter word that begins with P.
Yeah, exactly.
Purge.
Start purging and don't stop until you get well below that threshold, because you don't want to be anywhere near it either, because the chances are that lawyers who are going to get smart on how to go after people will find ways to kind of put you into that category if you're close. So you want to be way far from any one of these particular requirements. If you do sell information from consumers and that's your business, then you are, regardless of the amount of money or the number of records you have, you are going to have to comply with this. But that's a very, very small subset of our business community.
Is it only California businesses, Louis? Like, what about McDonald's? They're headquartered in Oak Brook or Oak Park, Illinois, wherever they're headquartered back there. Are they covered by this because they have stores in California, or is it only California-based and California-owned and operated?
So the way that the law is written, anybody, regardless of where they're headquartered or regardless of where their business is located, who has consumers that are located in California, that are domiciled in California, has to comply with this law.
Wow. So I buy a lot of parts from CJ Pony Parts, which is located in Harrisburg, Pennsylvania. Now, they sell their products to people worldwide, so I know they have to have more than 50,000 records. But is the law going to be interpreted as, if you have more than 50,000 records of California residents, then you have to comply, or just 50,000 total? All 50 states, territories, possessions, foreign countries, the whole bit.
I've seen it interpreted both ways. And I use the word interpreted deliberately because a lot of the provisions in this law, a lot of the business community was fighting this law, not because they want to deny consumers protections. They're okay with that. What they were concerned about was there's so many areas that are not clearly defined and not clearly spelled out, so that it creates a lot of potential for litigation. So, for example, I mentioned the security requirements. That's outlined by 3 simple words: reasonable security method.
Right.
So that's it. That's all that says the language in the Act. So who interprets what reasonable means, right? If a business has done what they think they needed to do and they're covered by the Act, but they think, hey, I've taken the proper steps, but then somehow there is a data breach or they're compromised and somebody sues them, because the other thing that the CCPA does that the GDPR does not do is it gives consumers the right to sue. And so consumers individually or collectively can sue if they think that their information has been compromised by a company, and the only reasonable, or what that company has to show is that, hey, we did everything we could to prevent this from happening. And then whoever's litigating it has to determine that, no, they didn't. But because you have this nebulous term, reasonable, it becomes a real crapshoot when it comes to litigation. And that's what a lot of the delay in implementing the law and, the final touches of the law until recently was caused by the fact that there was so much ambiguity that had to be ironed out. Even though they did put some things in place to reduce the ambiguity, there's still quite a bit of it. And that's what concerns those of us in the industry, is that, this is going to force people in one way do things that they should have been doing, secure their environments, provide good, secure websites. But on the other hand, it may be more than that's required. And even then they might still get sued and lose.
And I can see this kind of a law being challenged all the way up to the Supreme Court, because companies that are not based in California but have California customers are going to go to either the Court of Appeal in the district where their business happens to be located, and they might even try and get this expedited to the Supreme Court, that this is an unlawful overreach by the state of California. It's one thing to comply with, hey, I've got 10,000 California customers. Okay, I'll just get rid of their records and I'm good. The way that we're interpreting this, if you interpret it in the most severe manner, which may be the intention of the author of the bill, it covers everybody, right? And then you have a situation where California is making rules, they're making law that impacts residents of other states who have not even set foot in California. It's one thing to be a Nevada resident with a Nevada driver's license and you're driving on a highway in California and you're speeding and get caught. Okay, you violated a California law in the state of California. But to try and infer that the legislature in Sacramento can reach beyond the borders of the state, boy, I just see this as something that the Supreme Court, somebody's going to want to take this right to the Supreme Court and have it struck down as an unconstitutional ability of a legislature to legislate laws that would impact, because it essentially holds other legislatures captive, right? All of a sudden, they've been made to where residents in their state and their businesses and their own government could be impacted by this. I mean, imagine if you were in Pennsylvania, right? And you had, say you got a ticket in Pennsylvania. Now they've got a record of you online in in Pennsylvania, and the state of California is telling the state of Pennsylvania, their state troopers, their highway patrol department, boy, if you got any problems there, we're coming after you. Oh, boy.
Yeah. I can tell you from experience that the GDPR had much the same effect to a lot of companies that are located in the United States that didn't want to have to deal with it. So when you're there, like when recently, earlier this year, Ronnie and I went on vacation in Europe, and while I was there, some of the websites that I tried to call up would pop up with a message saying, you're located in Europe. Because of the GDPR, you're not allowed to access our website.
Right.
Because those companies didn't want to go through the hassle, the bother of complying with the GDPR regulations. So they basically said, we're going to block you people.
Yeah.
So the reverse might happen here, where a car parts company located in another part of the country says, you know what, I don't want to deal with the people in California. When you try to log in, it identifies your location as coming from California, and you get a pop-up that says, no, sorry, we don't do business with people from California.
Right. Or what it may end up happening is you can still go on their website and you can look at their online catalog. And then if you go and you try and order something, put in your zip code, something like that, you try and order it, and you'll get a grayed out box, and it'll say, because you're from California, we can't take an online order from you, but call our 800 number, and you can do by looking at the catalog online, you can make your purchase over the telephone with one of our sales representatives, kind of like what you did years ago.
Yeah, a distinct possibility. I think there are consumer privacy efforts going on in other states. Mm-hmm. Some are good, some are not so great, but none of them are as comprehensive as California's. But I think what you're finding is that a lot of the big companies that really can't avoid this whole thing are just going to take the rules that California has dictated and say, this is the way we're going to operate in every state. California is going to be the most restrictive, and if we do that everywhere, then we're going to be fine.
Well,
we'll impact the rest of the country regardless.
We'll see what happens. All right. Luis Alvarez, CEO of the Alvarez Technology Group, joining us today. Boy, what a fascinating topic to talk about. Stay tuned. Strap yourselves in, and let's see what happens on January 1st. Check out the Alvarez Technology Group online at alvareztg.com. At AlvarezTG is the Twitter handle, and Luis, the toll-free number for the I-Team.
Give us a call at 866-78-I-Team, and that's 866-784-8326.